Hello everyone, welcome to my channel, The Media. I'm Andrew. In this channel, we're going to unlock exponential gains together by looking at disruptive companies. Again, disruptive, innovative companies are companies that solve a problem in a creative way. Okay, returning by popular demand in this video, I'm going to do a comparative analysis between Philip Morris attorneys and HCMC's attorneys. In addition, I'm going to be analyzing the motion that was filed by Philip Morris on February 25th, 2021. I know a lot of people are panicking and thinking this is a motion to dismiss, and so HCMC doesn't stand a chance. I just think this is a very premature to look at it. Again, you can have attorneys talk your ears out, and you're not going to be convinced because you have attorneys that can speak on Philip Morris's behalf, and you can have attorneys speaking on HCMC's behalf. So the best way is for you to read the documents, use your own analysis, use your own judgment to make a determination. So in this video, I'm not claiming that I am a professional in any regards. I'm just a YouTuber, I'm the media. But I'm going to use my own brain, my own judgment to make these analyses, and I hope that you find this analysis helpful. Okay, so let's first quickly look at the motion that was filed. We see here the plaintiff is HCMC, the defendant is Philip Morris. This is a motion to dismiss HCMC's infringement allegation. So let's just quickly read this, and it's not very long, it's only 2 paragraphs long. So let's read this and break it down. Plaintiff Healthier Choices Management Corp. has asserted a claim for patent infringement against defendants Philip Morris and Philip Morris products that is implausible on its face and contradicted by the very exhibits included with the complainant that plaintiff relies on to support its claim. Consequently, plaintiff's pleading conclusively established that there is not and cannot be infringement. They're asking for motions to dismiss because they're saying that, well, it's implausible, it's not plausible that this could happen based on the evidence that HCMC submitted and that their evidence is contradicting. So therefore, dismiss it because it's just not plausible that we could have infringed on their product. So this is an argument that gives you no new information. For example, you are a parent and you have 2 kids. One broke a vase. Both of your kids to come in and you ask the kid, hey, so I know that you broke the vase because of this, this, and this. And the kid says, it's implausible. Like, how could I have done this? Implausibility is something that's really difficult to prove. Unless the child can say, well, I was actually on the moon when the vase broke. And have proved that he was on the moon, for this cannot happen. But we have to understand that this is not a criminal prosecution. The standard of proof that's required for this is preponderance of the evidence. You know, with criminal prosecution, you need beyond a reasonable doubt, which means that it's almost near a confession. With this, it's only preponderance of the evidence, which means that more likely than not, or 50% in a feather. Based on the analysis, based on what they submitted to court, which I included in my previous video, so check it out if you haven't watched it. I'll provide a link to this video to say why, to me, what they have submitted meets the prima facie evidence for them to get a hearing. Here, they're not giving you any new information. They're just trying to be that kid saying, hey, it's just not plausible for me to do this. And they didn't even give any reasons why it's implausible. Did they? No, they didn't say that they were on the Mars or on Moon when it happened. Also, if you like my work, please consider subscribing to the channel by hitting the subscribe button. If you are new to investing, you can open an account to trade OTC penny stocks with Charles Schwab. If you use my link to Charles Schwab, you can open an account and I think you get $100 for free. Using my links to open an account with Charles Schwab or Webull, you're supporting my channel. I'm not being endorsed by them at all. Number 2, they're saying that the evidence that was submitted is contradictory, but they didn't tell us what evidence is contradictory. Again, they're not producing any new evidence. How can a judge make a determination based on the self-serving testimony? I mean, I'm reading through this and I'm thinking as if they are the judge and they've already made a final decision. There's no legal analysis here. All right, let's read on the next paragraph. In addition, dismissals is warranted on plaintiffs' indirect infringement claims for a separate and independent reason. Alleged indirect infringement, the patent law requires a plaintiff to plausibly allege that the defendants had pre-suit knowledge of the asserted patents. Rather than alleged knowledge, plaintiff speculates that the defendants knowingly induced and contributed to infringement without any supporting factual allegations. For this independent reason, dismissal of plaintiff's indirect infringement claims is also required. So, again, they're just basically saying, it's almost like an admission saying that, oh, so they do have a patent on this product. They're saying that, well, they need to prove that we knowingly knew this, but we also used it anyways. Again, when it comes to pre-suit knowledge, we are not asking for the highest standard of proof in a criminal investigation. It's only preponderance of the evidence, which is 50% and a feather, more likely than not. So to me, as a reasonable person, I'm going to say Philip Morris is one of those big, tobacco company. They've been in this line of business for a very, 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 very long time. They are a leader in this industry. How likely is it that they don't know about this? To me, they're more than likely to know about it. So to me, that argument is already preponderance of the evidence. It's persuasive to me to say that they, because of their size, because of their time in the business, in the industry, their expertise, that they're the ones that should be producing these things. If not, they should know about all these things. So that's more likely than not. They're more likely than not to know these things. And HCMC advertises on their website that these are their patents. And I'm sure they have conventions and these types of things in any industry. They have convention, they have share knowledge. So I think that it's pretty easy for HCMC to produce evidence that, we've had publications on our patent and we've explained to people, this is our patent, that a person that you would expect any reasonable person who's been in the industry for a set amount of time to know something about this. So to me, again, producing no evidence at all, and it's just based on hearsay. In the court of law, hearsay doesn't stick. You have to produce evidence. Here, they haven't produced any new evidence to counter the argument. This is going to get dismissed quicker than me flipping my hand. So another thing to notice here, I've noticed, is that, the 4 panel members, one is Charles Panel, the other is Henry Fellows, Latham Watkins, and Will Gottsell. If you go all the way down, you'll see that Charles Panel is the one who made the certification for Philip Morris. Based on him signing on behalf of the other 3 panels, that he is the lead panel member. So what I did was I went to look for him. One of the things I immediately noticed is that all of these are not in-house counsel. These are outside hires. So Philip Morris, even though they have in-house lawyers, they have their own legal team, but chose to hire prominent lawyers from the outside. To me, they're saying, oh my goodness, this is a serious case. They have a serious case against us. And our in-house counsel are not strong enough. We're going to go and hire the best of the best. Only people who are fearful would do something like that. If they used in-house counsel, then I would be a little more fearful for HCMC. But the fact that they went all out and spent a lot of money to hire really decorated attorneys, I think it's good news for HCMC. Let's go and check out the lead panel member. And I actually found something quite interesting that I want to show you guys. So his name is Charles Panel. He works for the law firm Addy Hart. One thing I immediately noticed is that, this guy works in patent litigation. Obviously, that makes sense, right? But in his practice areas, you do not see cannabis. The other 2 attorneys that we found for HCMC, they have specializations in cannabis, in addition to litigation and patent laws and intellectual property rights. So to me, that's already a winning point for HCMC. Mr. Charles panel, obviously, he's decorated as well. Super lawyer, Georgia Rising Star in litigation, 2009, 2011, 2016, 2017. Again, great. I don't doubt his qualifications at all. Philip Morris paid a lot of money for this guy. But all of these awards were from 2019, nothing from 2010. Whereas the lawyers from HCMC received their Rising Star Awards in 2020. So that means that they are current. What I really found to be extraordinary is in the litigation summary for this law firm. Second sentence, let me read it to you. Addy Hart's attorneys have helped clients negotiate favorable settlements to secure multi-million-dollar jury verdicts and to enforce their intellectual property rights. So if you are very confident about your case, Philip Morris is, why would you hire an attorney and have this attorney be a leading panel member from a company whose attorney have proven to help clients negotiate favorable settlements, right? So they're thinking, okay, so the chances of us losing might be great. So we might as well set up a panel member with a lead, have had experience in drafting, settlements that are favorable to us. So this is great news for HCMC, at least to me. I've also looked into the biography for the other three, but I can tell you that, the thing that I can pull out is the fact that the other three, none of them have specializations in cannabis. They have specializations in litigation. Like I've mentioned before, information have changed. I don't really understand why people are panicking. Truly don't understand why people are panicking. I mean, if you were to read this, it's so reasonable that they've got nothing. Well, I hope that you found the information helpful. Please let me know by commenting below. Thank you very much and take care.